All right, we're here today for a pretrial and a bond violation in this case. What would you like to do, Mr. Burkett?
Well, I would like for you just to dismiss the whole case and everybody go home, but that's not gonna happen. I spoke with the prosecutor several times, and to be really candid with the court, I don't really understand what was happening, what our prior attorney did. But in the meantime, based upon the meeting we had last week, I asked I think she applied to Don's farm. It's my understanding that they've interviewed her and they told me that they sent you a report. They haven't, for some reason, they haven't sent me a report of it, but I was told that they did forward one to you. I also spoke with Mr. Ray from 14B. I'm sorry, Your Honor, were you saying something?
I don't have a report, but you spoke to who?
Mr. Ray from the 14th District Court. I got an email from him saying that he's interviewing my client this week to see if she can get into their program or in-house or you know, an in-house facility. And I spoke with the prosecutor Friday about how we're going to deal with this. So I guess I was waiting to see if she was going to be admitted to Don's farm, or or Mr. Ray said he would advise me this week. But now, in terms of the pretrial, I've talked with my client, and I explained to her all of her constitutional rights, and she understands them. Because she had, I'm sorry, Johnny, you're breaking. Did you say something?
No, I did not. That's the jail.
Oh, okay. As I was saying, I talked with my client, and she does understand all of her rights. But because she has no memory of what transpired, and I don't know what her other attorney had done on the case, I advised her that in terms of the bond violation, based on the reports that I received from the prosecutor and going over with my client, that we'll plead no longer contender if this honorable court will accept it.
You want to plead no contest to the bond violations, is what you're saying?
Yeah. Yes, no, because she has no memory of what transpired.
Ms. McDuffie, what is your position on a no contest plea to the bond violation? I think we're here for the scram tether violation.
Correct. I know we had discussed that with respect to the actual underlying pretrial. So the bond violation is a little bit different, Mr. Burkett, because if this had been maybe a little bit earlier on and the circumstances were a little different, I don't think I would have necessarily objected. But for this to be the most recent of, I can't count how many individual ones. I know we have 3 or 4 reports. I'll leave it to the court. I'll just say that.
You understand, I didn't get into this case until a few weeks ago, and I would have dealt with it totally different in terms of a pretrial.
I understand, Mr. Burkett. I'm just on the bond violation, the most recent bond violation now.
So this encompasses the December 31st, 5:26 a.m. tamper that was detected and lasted until 9:35 a.m., 4 hours and 9 minutes, where alcohol was detected. And then December 31st, from 3:49 p.m. until January 1st, New Year's Eve, at 8:57 a.m., where she was tampering for 17 hours and 8 minutes. And then January 6th to January 7th for 1 day and 2 hours where alcohol was again detected. And then January 8th to January 9th for 22 hours and 37 minutes where alcohol again was detected. And from January 10th to January 11th, in which for 17 hours and 42 minutes, in which alcohol was again detected. So you're telling me that she has no recall of any of those incidences?
Judge, she doesn't, and I kind of, and I do believe her, John.
The only way I would accept that is if she's going to acknowledge that she was drinking to the point of having no memory. We can just have our hearing.
One second. Ms. Clay, did you want to say something?
Yes, we were talking about me not having not knowing about the sock underneath my tether. Is that what we're talking about for all those days and those hours?
No, we're talking about the fact that alcohol was detected.
Yeah, I'm sure it was, but I was at work. I'm sure it was detected a couple of times, but not as far as alcohol consumption. Alcohol detection, yeah, yes, Your Honor.
I don't even know what that means.
As far as maybe I was using perfume, or like I said, I'll be at work 12 hours, hand sanitizer.
Absolutely not will I accept the plea based on that.
Yeah, Your Honor, there's no way.
So, Your Honor, I'm not actually, Mr. Burkett, I needed to know if we were definitely going to go through with the hearing because I don't have, the witnesses here today. In order to do that, I know she had brought up hand sanitizer last time, but when we talked, I was under the impression that she was going to be entering a plea on the underlying case and that in potentially admitting to the violation. So I don't
I can admit to the violation. Yeah. Well, and also I thought that I was going to be put in inpatient treatment, and I had an assessment. Well, I was on the phone with Amanda. I had kind of Patrick. And he said that he was going to give my referral to Judge Washington. And I had spoke with him on the 16th February. And that's when I got my referral.
What are we doing today, please?
Well, I thought we were going to enter a no contest on this.
I'm not accepting a no contest when she's claiming it was perfume. So she apparently has recollection.
But you remember everything we talked about yesterday and last night?
The other problem I have, Mr. Burkett, is, she's saying she wants to go to treatment, but in reality, she's saying that she wasn't using any alcohol, and this is from perfume. So why would someone want to go to treatment who has actually no admission or acknowledgement of having an alcohol problem?
Yeah, Yana, we discussed that, and she knows she has a problem. I don't know why she's telling you she doesn't have a problem. She knows.
And the letter of what
I'm going to do today, that's in her best interest to plead no to this guy. I understand your position. She definitely wants to go to treatment. She knows she has to go to treatment, and we're trying to get her in a treatment program. And everybody seems to be cooperating with me, but they won't release the reports unless you. That's
not, well, so first of all, Mr. Burkett, that's not how it works. What happens is they interview her, they determine whether she's eligible for treatment. If they find that she is, they send me over a request to release her once a bed becomes available. So one of two things is happening, and I cannot tell you which. Either there is no bed available, or she gave them the same malarkey that she's giving me, and they decided she didn't need treatment, and therefore they're not referring her to treatment. So I can't tell you which of those is occurring.
I have to believe that there were no beds available. I cannot believe she told them what she told you this morning, this point.
Well, if she did, why don't I put you in a breakout room with your client so the two of you can talk about what we're going to do today?
All right.
Thank you.
White, it's my understanding that you're going to enter into a guilty plea as to both the bond violation and the operating while intoxicated, impaired second offense. Is that correct?
Yes.
Please raise your right hand to be sworn, Ms. White. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, ma'am.
Yes,
January the 31st at 5:26 a.m., you tampered with your scram bracelet and it lasted until 9:35 a.m. And during that 4 hours and 9 minutes, alcohol was detected.
yes.
I find that there is a factual basis for the plea has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Mr. Burkett?
Yes, yeah.
Ms. White, I'm going to accept your plea. And Ms. White,
Yes.
you had similar issues when you were on probation last time. You ended up, I think, finishing out your term on that probation and you did some jail time. I going on recall, but at that time, I think we tried to get you to see how serious this was and how you have an issue. You're going to keep coming back here and you're going to end up in prison, ma'am, if you don't fix this issue.
I understand, Your Honor.
And I'm sorry that you are here because otherwise you seem like a very nice person, but you just can't get this under control. And the longer you're in denial over it, the worse your consequences are going to be.
I would like to get it under control.
Well, if they send me the paperwork, I will release you to a treatment.
Okay.
And I pray that you really, really take advantage of that opportunity. Because if you don't, people aren't going to be willing to give you an opportunity.
I understand, Your Honor.
All right, I'm going to schedule you for sentencing. That'll be April 1st, 2024 at 10 a.m. Bond is continued with defendant released to treatment. So you need to keep talking to them about when they can make that happen. I hope you told them the truth, ma'am, because otherwise they won't let you into treatment.
May I ask a question, Your Honor?
Sure.
So the assessment I did with Patrick, he said that he was going to send it over, the referral over to you?
They never send me the actual assessment, Ms. White. They only send me a request for you to be released to treatment once the bed is available. So
I see. Okay.
if they've assessed you and there's not a bed, they're not going to send it to me yet. They send it when the bed is available.
Oh, okay. I see.
Okay.
And Your Honor, just one
Yes.
thing, something that may be causing some additional confusion is that Ms. White's previous attorney, Mr. Lebo, had adjourned a number of times for her to get an assessment, and that was completed. And I think that may be gumming up the works with the understanding of what report is being sent where and for what purpose. So she went to Statman back in December or so. Yeah, December 4th. So we do have that report or that assessment, but I think that may be causing some issues too.
No, I think they do those completely separately. Once she's interviewed in the jail, then if she's deemed eligible through Don Farm or whatever program they want her to send her to, they keep that there at community corrections, but then they send me the request to release her only once the bed is available. So they may not even know about the Statman thing.
Oh no, I meant on the part of Mr. Burkett and Ms. White, that interview that she did may be causing some confusion with what has to happen now.
No, I think he said that she was interviewed by Don Farm.
Okay.
Yeah. Am I correct, Mr. Burkett?
That's what I've been told, Your Honor, yes.
Thank you. So, Mr. Burkett, you might want to call over to correctional services there to confirm that she's been interviewed and is eligible to go to that programming. Okay.
I'm going to do that. Your Honor, sentencing, will it be on Zoom?
Yes, it will be on Zoom. And if she is at Don Farm, they will bring her on Zoom from Don Farm to be on Zoom. They will put it on Zoom for us. Okay.
Appreciate it very much. Thank you.
Thank you. Thank you. Ms. White, what would your client like to do?
Admit to the violation with an explanation.
Mr. Buck, please raise your right hand to be sworn. Do you swear from other right, sir? Do you
Yeah.
swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. So, sir, is it true that you missed your test on December the 12th, January 10th, January 17th, January 30th, February 5th, and February 16th?
Yes, Your Honor.
Find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Satisfied.
Thank you. So please explain how I would please explain, because we've been dealing with his mistest since he first started this in June. And this is the third violation for missing his test.
I did
oh.
discuss that with Mr. Buck. He said that in the last couple months, his truck went down, and because his truck went down, he had no transportation and he could not also go to work. So he had no money to do a Lyft or an Uber. And therefore, he also had no money to test. He did try to get rides, but because he had no money to pay for the testing, he was unable to also pay anybody to give him rides. He did try to contact Ms. Wild on several occasions. He finally got in touch with her last week, and Ms. Wild said she hadn't gotten the messages, but he did try to get in touch with her several occasions over the last few months.
Ms. McDuffie?
Where to start? So first, with respect to, I'm not sure what the issue would have been trying to contact Agent Wild, especially over several months. I don't understand what that's about. Why phone, email, whatever methods of contact would not have been successful trying to reach her. So I don't understand that part. And why contact would not have also gone out to basically everyone, the attorneys, the court, when there's an issue and Mr. Buck knows where he stood with respect to testing. I would think, if I were in that position, I would be ringing all the alarms to everybody I could, trying to make sure that they knew that I was making the attempt to comply. So I'm not really sure about that part. With respect,
I'm sorry.
with respect to the truck, Mr. Buck gave us an explanation about that the last time when we were here on December 11th, and he talked about he had proof of his truck being towed and things like that. So Mr. Buck, are you talking still?
No.
Okay. So it's been I guess a known issue at the least that there was some sort of car trouble. Actually, that was we have been here since then on January 22nd, and he had, some violations or some mistesting too. So if it's been an issue with the transportation and his truck not being reliable since December, I understand funds are limited and a person can't necessarily Uber everywhere they need to go. But again, I don't understand why we're here today hearing about all of this as if it's sort of well, it's not new, clearly, because we've been here before. But that explanation, we've heard it before. And I'm still not really sure how to take the representation that his agent was not reachable, especially for that long period of time.
Is it okay to speak?
Yes, sir. If it's okay with your attorney.
Mr. Buck, do you wish to speak? Although I did speak to the court, you still wish to speak?
Yes, please.
Okay.
I had been advised by Attorney Lebo at the time of the matter when this took place, and which is congruent with the start of me missing the test. He had asked me, he said, okay, I'm going to text you my email me the photos. And then right after emailing the photos to me, call Ms. Wild to get a hold of her. Well, I called her 4 times right after I emailed the photos that day when it started, and left 2 voicemails. And I don't know what had happened, but every time that I would try to get a hold of her, it would go to voicemail. And I know of one occasion where I called her and she was on lunch, which I can vouch for that. And that was the only time that I had called and they had told me she was on lunch. Other times it went to voicemail, so I left her voicemails. And then I wasn't able to actually speak with her until this past Wednesday when she had ordered the violation, when she had published it. And I said, well, I was advised by my attorney to do these things in this order. And I had imagined, I would hope that the photos in which Mr. Lebo got on his email would go to the courts, and that he further asked me to explain my circumstances to Department of Corrections. And I don't know. And I said, I don't understand, if that's been sent to you or the court or whatever. And she had explained to me that she alleged that she hadn't got any calls. She hadn't had any voicemails. And I was like, well, I spoke to the front desk 4 times in one day. And they were getting kind of irritable about it because I kept trying to get forwarded back, and I just kept end up calling it over and over again. And they had explained to me to try and call the next day because they're really busy. So I did. And it never went through. And then Wednesday, I finally got a hold of her. I was able to explain to her and, finalize what I need to do to make sure that I don't end up in jail, because I don't want to be in jail. Nobody wants to be in jail. And I'm trying to abide by these terms. And I was in a position where my truck was inoperable. I'm calling everybody I know and trying to cover my rear end as my attorney advised me to. And it just seemed like, and without money and everything else, it all got really bad really quick. And the only thing I could do at that time was get a hold of the Department of Corrections to explain to them and express to them that, hey, this is what's going on. My attorney advised that I do this after sending him photos. And that didn't happen until Wednesday this past week. I did everything I could to make sure that I didn't have to come here again on another violation, because God forbid, when I'm trying, something goes wrong, and here we are again.
All right, I find that the defendant has violated, and that I told you last time I would not have any excuses as to why you were not showing up to test, sir. So I meant that there were no excuses.
I understand, Your Honor.
Bond is revoked. You need to turn yourself in at the Washington County Jail.
Okay, can I have a certain time? I'm out of town at the moment. Not out of the state. Not out of the state. I'm just out of town.
Well, you can do what you will on issuing a bench warrant with no bond.
I was just asking, Your Honor,
Mr. Bond, I don't think you quite understand. When the court says test, it doesn't matter whether she had received those pictures or not. I was very clear with you that there were no more excuses. You needed to test. So that wouldn't have changed anything anyway.
I understand, Your Honor. And I, in the most indefinite understanding, was not trying to make an excuse or, claim I didn't understand or I had some misconception of what was said. I just was doing exactly as I was told, with the hopes that, I was doing the right thing, and in the best regard for the court, obviously, and the Department of Corrections and the bond, and myself, last but not least, under my attorney's advisory.
You've been on bond since June of 2023.
Yes, I believe it. Yeah.
And you're supposed to be testing, it looks like 3 times a month, and you've made maybe 12 of those tests out of that entire time.
Really? I do recall, Your Honor, my fault on the misconception regarding when I called the courthouse and they had told me that everything was on hold. I do recall that, and that was my fault. So I understand that it's been rough going. I'm just, and the same day that I got my truck back running, which was Wednesday when I got a hold of Miss Wild, I told her, I said, I can come in and do a
Mr. Buck,
test.
I think the judge understands everything now.
Okay. I'm trying not to end up in jail. I really don't. I got a kid and everything else. I just can't. I can't afford, let alone, just overall be in jail. Can't. I'm trying. trying to do right, but it just seems like, you know, you take one step forward and you set 10 steps back. It's crazy.
I'm all done with this case, Mr. Burke. Please turn yourself into the jail.